Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the First Amendment, pretextual stops, and retaliatory arrests, and is brought to us by Corners News' channel. Be sure to check out the description below and give them the credit that they deserve. On September 6th, 2023, Brittany Trevino drove by Officer Patrick Akers of New Braunfels Police Department as he was completing a traffic stop in New Braunfels, Texas. Several years earlier, Ms. Trevino had an encounter with Officer Akers where he forcefully detained her under questionable circumstances, and Ms. Trevino decided to express her feelings about Officer Akers by raising her middle finger at him as she drove by. The interaction that followed was recorded on Officer Akers' body camera, and, when the officers involved turned off their body cameras, on Ms. Trevino's cell phone.
Charles Paul 5990, Charles Paul 5890.
35-256. If it's possible, could you make my location? PD 256. Put me at the 1049 of Gardenia.
35 is on Gardenia. That's right.
Officer Akers claims he stopped Ms. Trevino for, quote-unquote, flicking him off, and allegedly failing to signal before changing lanes. As we have discussed before here on ATA, the Supreme Court determined in the 1989 case of Texas versus Johnson that the First Amendment not only protects written or spoken language, but also certain conduct that is, quote, sufficiently imbued with elements of communication. Accordingly, a communicative gesture, such as giving someone the middle finger, generally falls within the protections of the First Amendment. Although Texas's disorderly conduct statute, which can be found in Section 42.01 of the Texas Penal Code, prohibits making an offensive gesture or display in a public place when the gesture or display tends to incite an immediate breach of the peace. As the U.S. District Court for the Western District of Texas explained in the 2015 case of Brown versus Wilson, quote, "It has long been the law that Texas's disorderly conduct statute prohibits only fighting words, and that fighting words are limited to those personally abusive epithets inherently likely to provoke violent reaction. In this case, the court determined that an individual's conduct did not amount to prosecutable fighting words when he, quote, firmly gave the middle finger to an officer as he drove by in his vehicle, reasoning that while the gesture was offensive, it was not a direct personal insult or an invitation to exchange fisticuffs, and that because the gesture did not indicate actual or threatened violence, it could not reasonably be interpreted as tending to incite an immediate breach of the peace. Accordingly, it is highly likely that a court would conclude that Officer Akers could not have initiated a traffic stop on Ms. Trevino based solely on the gesture she directed at him. However, the Supreme Court held in the 1996 case of Wren versus United States that an officer's subjective motivations do not invalidate objectively justifiable behavior under the Fourth Amendment, and that the constitutional reasonableness of traffic stops does not depend on the actual motivations of the individual officers involved. In other words, even if it could be definitively proven that Officer Akers chose to conduct a traffic stop on Ms. Trevino because she flipped him off and only used the alleged failure to change lanes as a pretext for detaining her, as long as a court concluded that he had probable cause to believe that the traffic code had been violated, it would likely uphold the constitutionality of the stop, even if Officer Akers were to explicitly admit that the stop was pretextual. Nonetheless, while the body camera footage is not entirely clear, it does appear that Ms. Trevino may have signaled when changing lanes. Therefore, if a court concluded that Ms. Trevino did in fact signal, it is likely it would also determine that Officer Akers did not have probable cause or reasonable suspicion to detain her.
So this is that female Trevino. She flicks me off as I'm going back to back of my patrol car, fails to signal left hand to go into the left lane. She flicks me off, so I just wanted a second to make contact with her. How's it going? Officer Akers, New Braunfels Police Department. Okay.
I know who you are.
That's fine. Well, the reason why you being
over for flipping you off.
No, ma'am. The reason why
you are retaliating against me. You turned your sirens on and everything. Ran over here like a crazy person.
Okay. Well, ma'am, the reason why you're being contacted is you failed to signal lane change when you flicked me off.
Okay.
Okay. So go ahead and step out of the car. Step out of the car. I have 3 officers here.
He's hurt me before. Please don't let him.
Yeah. Would you mind Henderson, go ahead and detain her. In cuffs.
No, because he's done illegal to me.
Okay, alright, we'll just continue the violence.
You're under arrest for fail to signal lane change.
I'm under arrest for failing to signal a lane change?
Yes, ma'am.
I'm under arrest for failing to signal a lane change?
Yes, ma'am.
Stay still.
I'm sorry. You guys just know this is... You guys just know it is. You're under arrest. Grab my phone.
Officer Akers informs Ms. Trevino that she is under arrest for her alleged failure to signal. Now, while some states place limits on officer authority to make custodial arrests for traffic offenses, Texas law allows for arrests for minor infractions, such as failure to signal. Section 545.104 of the Texas Transportation Code makes it a misdemeanor offense for a driver to fail to signal before changing lanes. And under Section 543.001 of the Transportation Code, law enforcement officers are broadly authorized to arrest individuals who violate the so-called rules of the road based on probable cause, including a failure to signal. Nevertheless, it is important to note that even if the applicable state law prohibited arrests for minor traffic offenses, a court would almost certainly conclude that such an arrest was constitutional, as long as it was supported by probable cause. In the 2001 case of Atwater versus City of Lago Vista, the Supreme Court held that, quote, if an officer has probable cause to believe that an individual has committed even a very minor criminal offense in his presence, he may, without violating the Fourth Amendment, arrest the offender. Likewise, in the 2008 case of Virginia versus Moore, the Supreme Court concluded that an officer does not violate the Fourth Amendment when they make an arrest that is based on probable cause, but prohibited by state law. In the Moore case, the Supreme Court upheld the constitutionality of a custodial arrest on a citizen who was driving on a suspended license, even though Virginia state law required the officers to issue a summons rather than make an arrest. In its decision, the court noted that, quote, in a long line of cases, we have said that when an officer has probable cause to believe a person committed even a minor crime in his presence, the arrest is constitutionally reasonable, and explained that when a state chooses to grant additional protections beyond what was required by the Fourth Amendment, these protections are exclusively a matter of state law. The court ultimately determined that, quote, warrantless arrests for crimes committed in the presence of an arresting officer are reasonable under the Constitution, and that while states are free to regulate such arrests however they desire, state restrictions do not alter the Fourth Amendment's protections, in part because, now quoting again, linking Fourth Amendment protections to state law would cause them to vary from place to place and from time to time. Accordingly, even if Texas law explicitly prohibited officers from conducting probable cause-based arrests for traffic offenses, it is highly unlikely that a court would conclude that such an arrest violated the Fourth Amendment. Now, of course, as we discussed earlier in this episode, it is questionable whether Officer Akers had any probable cause to believe that Ms. Trevino failed to signal, and if a court determined that he did not have probable cause, then the arrest would almost certainly be both unlawful under state law and a violation of the Fourth Amendment. However, if a court concluded that probable cause existed, then it would likely find that the arrest was lawful, despite the minor nature of the traffic offense involved.
You want me to transport, or you think better?
Yeah, Danny can do it.
Danny, would you mind just transporting? You don't have to do anything else other than transport. I'll be there. PD 2B6.
Go ahead.
Can you go ahead and give me next rotational record? That female is in my custody. I believe it's going to be Brittany Trevino.
6-10, when in custody at 8:39.
Yeah, she has a driver's license, but...
I'm going to turn this off. Go off.
Well, she comes down the street, comes right towards me. As I'm walking back by the car to do nothing, she flicks me off. And then as she does that, she gets on the lane and fails to signal lane change. You think it's going to be an issue?
Given your history, right?
Yeah.
So, any other person you would write a ticket to, right?
Yeah.
That's how you have to treat every interaction. You would normally write a ticket to this person for this, just because that in the past you've done this, this, and this, right? This is something that you would normally write a ticket for, and then it's write a ticket for.
Sergeant Scott orders Officer Akers to release Ms. Trevino, arguing that he cannot arrest Ms. Trevino for an offense for which he would typically issue a citation. As the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, explained in the 2021 case of Oliver versus Arnold, quote, a government official violates the First Amendment by retaliating against a person for exercising First Amendment rights. That is, by taking so-called adverse actions that cause the plaintiff an injury that would chill a person of ordinary firmness from continuing to engage in that protected activity. One type of so-called adverse action that can support a First Amendment retaliation claim is a false arrest. But in the 2019 case of Nieves versus Bartlett, the Supreme Court held that in First Amendment claims involving a potentially retaliatory arrest, quote, the presence of probable cause should generally defeat a First Amendment retaliatory arrest claim. Accordingly, if a court concluded that Officer Akers had probable cause to arrest Ms. Trevino for the lane change violation, it is likely that under the general rule requiring probable cause, a retaliatory arrest claim from Ms. Trevino would fail. However, the Supreme Court also recognized in the Nieves case that, quote, although probable cause should generally defeat a retaliatory arrest claim, a narrow qualification is warranted for circumstances where officers have probable cause to make arrests, but typically exercise their discretion not to do so. In such cases, an unyielding requirement to show the absence of probable cause could pose a risk that some police officers may exploit the arrest power as a means of suppressing speech. The court accordingly determined that, quote, the no probable cause requirement should not apply when a plaintiff presents objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. In this situation, the fact that Officer Akers admitted that he would have written a ticket to any other citizen for a failure to change lanes suggests that Ms. Trevino could potentially succeed in a retaliatory arrest claim under this narrow exception to the standard probable cause requirement.
Yeah. You want me to go ahead, Alicia?
Yes.
Yeah.
Procedure for the plate for Charles Paul 5990 for number 3, Volkswagen 4 more phone code.
ED35, cancel order. Take the ticket. Alright, so let's write the ticket and go about it that way.
Sounds good.
All you're going to do is give her more ammo. Alright?
Yep.
So, write the ticket, just fill it out.
I didn't mind. Yeah, I did.
Brittany, come here. Can you go way by the back of the car, please? You're good to go. So I understand that you flicked the officer off. So my question was, did you flick the officer off?
Yes.
Okay. So here's the thing, right? Had you just gone on about your day, right? Your intense hatred is causing you to do other things that is drawing attention to you. I'm not here to debate this situation with you. I watched the video. I know everything that occurred. Okay? I know about the court stuff, everything that occurred. If Officer Akers had done anything wrong, he wouldn't be here right now. Right? That's 100% true. You need to move on and not be running around flipping people off. Right? I get it. That's your First Amendment. If you want to flip people off, but what it did is it caused you to create a hazard to a traffic infraction right in front of an officer. If you choose to be defined by what happened to you in the past, then you will always continue to be that person. Regardless of what y'all's history is, you need to move along with it. Right?
After Ms. Trevino received a citation and a lecture from Sergeant Scott, she was permitted to leave. Very little information is available about this encounter, and it's unknown whether Ms. Trevino contested the ticket, filed a complaint, or intends to pursue legal action. Overall, Officer Akers gets an F for driving recklessly in his attempt to catch up with Ms. Trevino's vehicle and pull her over, attempting to arrest her in apparent retaliation for engaging in protected First Amendment activity, and potentially manufacturing a traffic violation in order to justify his actions. Whether or not Officer Akers actually believed that Ms. Trevino failed to signal, it seems clear that the actual motivation for the traffic stop was Ms. Trevino's use of the middle finger. And although the Supreme Court has held that pretextual traffic stops based on probable cause are constitutional, that does not mean that such detentions are professional or desirable police behavior. Even if a court determined that Officer Akers did have probable cause to believe that Ms. Trevino had committed a traffic infraction, Ms. Trevino would have a strong case for First Amendment retaliation, given the fact that Officer Akers openly admitted to treating her differently than other individuals who allegedly failed to signal before changing lanes. This sort of retaliatory action by a police officer is completely unacceptable, and I would strongly encourage the New Braunfels Police Department to take appropriate disciplinary action against Officer Akers. Sergeant Scott gets a C- because although he prevented Officer Akers from taking Ms. Trevino into custody, he waited until after she had already suffered the trauma of being arrested, and he had turned off his body camera to challenge Officer Akers' actions. Sergeant Scott then proceeded to engage in victim blaming by telling Ms. Trevino that she was responsible for everything that happened during the interaction and needed to change her conduct in order to prevent future retaliation from Officer Akers. There's not enough information available about Ms. Trevino's prior encounter with Officer Akers to determine if her rights were violated, but Sergeant Scott's assertion that if Officer Akers had done anything wrong, he would not be there is laughable, particularly given the fact that he had literally just attempted to conduct a retaliatory arrest against Ms. Trevino with no apparent consequences. This encounter demonstrates the substantial impact that a supervising officer can have on the course of police interaction. And although Sergeant Scott did protect Ms. Trevino from going to jail, he did not do enough to defend her rights in this instance. Ms. Trevino gets an A for physically complying with the arrest while voicing her strong dissent to the officer's actions and taking action to record the parts of the interaction that would otherwise have not been captured. Although I generally do not suggest that citizens make offensive gestures towards officers, Ms. Trevino was well within her First Amendment rights to do so, and it is quite clear from her emotional state during the encounter that she suffered a substantial amount of hurt during both of her interactions with Officer Akers. While I do not have enough information to assess her first encounter with Officer Akers, it is clear that it was a traumatic experience, regardless of any of the legalities involved, and I would encourage her to, at the very least, file a complaint and consider taking legal action, if she has not already done so. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.